Good morning, Joshua.
In 3, 2, 1.
And Jennifer. Good morning, and welcome to the Board of County Commissioners Board Work Session for Thursday, October 15th, 2020. And this is on the 2020 Comprehensive Plan Update follow-up regarding mineral lands. I'm John Hutchings, the chair of the board. Also present is Vice Chair Commissioner Ty Menser, County Manager Ramiro Chavez, and we have our CPED, Community Planning and Economic Development, Director Josh Cummings, and we have Jennifer Davis and Maya Teeple joining us as well, experts. And so I'll start with you, Ramiro.
Thank you, Commissioners. As the briefing stated, this is a follow-up to the initial briefing you had maybe a couple of weeks ago related to an update on the comprehensive plan. It was a couple of items updated at that time, and this is specifically related to the mineral lands, as you stated. Staff is going to walk you through the background as to how we got here and outline some of the potential options available to the board as to next steps. I don't think is a decision by today, but perhaps a direction will be helpful soon based on the options presented. As Josh is going to maybe state, this is a commitment from the staff. They have delivered portions of the comprehensive plan, and whether the board needs additional information or not, the intent from staff to keep moving forward to meet the intent of the board's direction. Josh?
And I'm sorry, can I interrupt you?
I'm done.
Okay, I might add that if you want to listen in, the phone call or the conference call number is 360-252-9020, and your PIN number is 1234. And as I didn't mention this earlier, but this is a board staff briefing or board briefing, a work session. It's not interactive, and I'm going to understand there's going to be more people joining in the conference call or on Zoom, but it's not meant to be interactive with the commission at all on this topic. And I see that we have Travis Burns from the Prosecuting Attorney's Office who's also joined us. Welcome, Travis. So am I going to...
and Commissioner Edwards just joined the room also.
Thank you. Josh?
Thank you, Chair Hutchings. And the county manager is exactly correct that I was going to say this is an opportunity for the board to hear this item, but a recognition also that this is a success in terms of the direction the board continues to provide on the prioritization for the docket items. So thank you once again for that direction. And then a thank you to our staff in the capable hands of Maya and Jennifer, who will lead you through this topic. I'm going to watch via the live stream, but I wanted to take this quick moment at the very beginning just to provide my appreciation one more time and relay this is the process, and that this success is in the process so that we continue to have this conversation with community members so that the board can hear all views to make a determination and direction based on those views. So thank you to staff for facilitating that conversation. And unless there's anything further, I will log off and go to the live stream. Jennifer, take it away.
I would also like to add, though, my appreciation to Jennifer and Maya also outside of work hours to bring me up to speed in last week on this topic. So thank you very much.
Thank you, Commissioner. I'm going to take the ball just for a minute. Jennifer Davis, Community Planning Manager, and I want to acknowledge a couple other people who've joined us of your Planning Commission. And we had asked him to join this meeting because that is our practice whenever we are bringing recommendations to you from the Planning Commission where the staff may have a different recommendation, which, as you know, and we'll get to these options when Maya goes through it, but we had conversations around whether or not to co-designate mineral lands and long-term agricultural lands. And that's of one of the topics that I think could benefit from additional perspective from Chair Nelson if you, when we get to that point and you want to hear from him. We also have Travis Burns in the room because as our legal counsel, he can help us with any particular questions about the many kind of legal aspects of the case, which are detailed in a lot of detail in your packet and that Maya will hit the highlights of. But he's he's here for those types of questions. I see Chris Hawkins is joining. Although this is focused on mineral lands today, Chris was really integral in helping us update the public health chapter of the comprehensive plan. And so if you had any lingering questions about that chapter toward the end of the briefing, feel free to ask them as well.
Thank you.
And I'm going to turn it over to Maya because she's the one who really knows what's going on here and can walk you through this very big topic.
Thanks, Jennifer. So I'm going to share my screen. I have a pretty lengthy PowerPoint today. So is that visible now to everyone?
Yes.
Great. So thank you, Jennifer and Commissioners. Maya Teeple with Community Planning. This is a follow-up brief from our October 1st brief on the broader 2020 Comprehensive Plan update. And the purpose of this briefing is to provide more details as requested by the board on the mineral lands portion and the options that are associated with that. So just an overview of what we're going to be covering today. This is mineral lands specifically. So mineral lands is one of the 4 continuing items that are part of the 2020 Comprehensive Plan update. And the other items are long-term forestry, health, and parks. And we covered those at the October 1st briefing. But mineral lands is kind of the bulkiest of the changes. So we're going to be diving into what some of the proposed options with that update are. I will go over the Planning Commission recommendation again, just as a refresher. We provided that on October 1st, and I will cover that again. And then I will discuss the next steps for the proposed amendments and what some of the options are for the board moving forward. So the goal of today's briefing, this is primarily an informational briefing, and we are asking for a direction from the board. So not a decision, but a direction on what additional information, if any, the board would like prior to directing staff to set up public hearing. So if there are more details that need to be discussed in a future work session, or if the board would like staff to go back to the drawing table and consider any additional options, that is the direction we'd be looking for at this briefing. So I'm going to start by going over a history of mineral lands, going all the way back to 2003. This is when the bigger changes started. So in 2003, the board at that time enacted a moratorium on new designation of mineral resource lands. And between 2003 and 2010, Thurston County convened a mineral lands focus group and had several discussions with that group over 7 years, lots of planning commission review, lots of board review. And out of that came revised designation criteria. That revised criteria was adopted in 2010, and Thurston County was appealed on that criteria. That appeal went to the Growth Management's hearing board. There were a series of revisions that occurred. One revision was adopted in 2012, and the county had to make further changes after that revision. And then in 2013, the county adopted revised criteria yet again. That is the criteria that's in the comprehensive plan today. So that designation criteria was adopted in 2013. And with that change and that adoption, the Growth Management's hearing board found that the county was in compliance with the case that was brought in 2010. However, there was one lingering piece of that update. So we adopted the criteria, the designation criteria in 2013, but the county did not update the map of designated mineral lands and said, we will do that update when we do our big comprehensive plan overhaul with a periodic update. And so that is what this update is now, is to update the map of designated mineral lands to be consistent with that criteria that was adopted in 2013. So I want to go over that case very briefly, pretty high level, and I do have Travis here with me if there are questions that I can't answer. But back in January, when I provided an introduction and refresher on mineral lands, the board asked for some more information on this case. And so this is to meet that request. we were challenged on the resolution 14401 and ordinance 14402, which adopted revised criteria for mineral lands. And there were several petitioners that challenged that criteria to the Growth Management's Hearing Board. Some of those petitioners were Sagale, the Washington Aggregate and Concrete Association, Alpine Sand and Gravel, Glacier Northwest, Cal Portland, Granite Construction, Miles Sand and Gravel, Quality Rock, and Weyerhaeuser. And those petitioners brought forward a set of 23 total issues, and the Growth Management's Hearing Board stated that the county must reconsider 7 of them. So the 7 issues were primarily focused on 2 main topics. The first topic was the exclusion of dual designation of forest lands. So at that 2010 adoption, the county did not co-designate forest lands and mineral lands, and that was one challenged component. And the second piece that was challenged was that the county excluded a number of critical areas in the designation criteria. So that was another piece that was challenged by the petitioners. There were a number of other components of that case, but those two pieces make up primarily the 7 issues that were brought forward for the county to reconsider. So the county did a couple updates. In 2012, we adopted revised criteria that cited science for excluding forest lands and mineral lands, and the Growth Management's Hearing Board held yet again that the county still needed to reconsider that further. And then in 2013, the county adopted revised criteria, which is what we have today in the comprehensive plan. We pulled all of the critical areas out of the designation criteria and left it to the development code. And also the county co-designated forest lands and mineral lands. And with that update and that revised criteria, the Growth Management's Hearing Board found that the county was in compliance with that case. They closed that case in 2013, so it is closed and finished. And that resolved it, and that's how we got the criteria that we have today. I do want to note that the 1,000-foot consideration was not one of the items that the Growth Management Hearings Board held that the county needed to reconsider. So are there any questions on that case before I move forward?
Commissioners, any questions?
Not yet.
Okay. I think I have one question, and we currently have. Did you say, Maya, that we currently have co-designation?
Of forest lands and mineral lands.
But not ag.
Not of agricultural lands
Okay.
and mineral lands. And that was not specifically challenged. Forestry was specifically challenged.
Okay, so maybe this is a question for Travis then. Is Thurston County liable for not co-designating ag lands with mineral? Or is that something you can answer?
No, I mean, I think it's a good question. It's certainly something that needs to be addressed one way or another. Just to be clear, what Maya's going through and what these these cases have to consider are what is termed minimal requirements of the DMA. And one of those minimal, what this case back in 2010 came up with was, that really the rules require co-designation unless there are specific local conditions that would justify otherwise. And so it's under the rules, the county could depart from co-designation if one, it makes fairly detailed findings and information that says there actually is a conflict between those. So if you can document, there's a conflict between ag and, say, mineral lands. And then the second thing we would have to do is come up with some documentation of which long-term commercial use is prioritized. And those are just going back to the case with forest land and mineral lands, that documentation was found to be insufficient. I should add the county did provide quite a bit, but the board in that instance said, no, that's not enough. You need to meet the minimum requirement of co-designation. You did not fulfill the exception. So I won't say that that's not an option forward. If the facts show that we should deviate, then that's a possibility. But without those findings, it's pretty clear that the board will want to see co-designation when it comes down to, mineral lands, ag lands, and long-term forestry. I don't know if that helps at all.
It does. It helps quite a bit. Thank you.
But
Go ahead.
I have a question when you're done, sir.
Well, I just have one final question at this point. Maya, you said something about the 1,000 foot. That's already in, but it was not challenged.
It was already in the criteria and it was not challenged. It was not one of the 7 items that the county needed to reconsider.
No, 1,7. Okay, thank you. Go ahead, Gary.
Maya, on that 1,000 foot issue, are there any other jurisdictions that have that same criteria in their plan?
I don't know off the top of my head. I would have to go back and look that up. I believe we've done that analysis before. I'm not 100% sure off the top of my head.
Travis, would you know the answer to that?
No, sir, I don't know the answer.
So there's quite a dispute about how that, whether that was arbitrary when it was put in place by parties involved. I wasn't here, and I wonder, was anybody here when that 1,000 foot was put in place? Are there any current employees that are here today?
I was not here during that time. I think Jennifer may have actually been here towards the tail end of those discussions, but
I think I was there for the beginning. I remember working with the early mineral lands focus group, and it was facilitated, and there was a lot of discussion amongst the stakeholders involved to try to negotiate basically a proper distance to create this separation that folks felt were important between mineral land activities and other rural land activities. I believe there was a lot of discussion around it. I don't believe I was here for the adoption action or the ultimate findings that were put into place, but I do recall this was a topic that was worked on quite a bit by the stakeholders at the time.
Oh, okay, I guess recognizing that it has been an ongoing issue for, I don't know, maybe 10 years as to how this was one of the criteria developed and the controversy around that. Jennifer, I'll ask you then, are you aware of any other jurisdiction that has this issue placed within its guidelines, the 1,000 foot setback?
No, and I'm happy to actually do a little bit of research on that, bring that back to you, maybe even in the course of this briefing. So we do some check-in.
That would be great. I think it's a big issue that's not, it's kind of like the elephant in the room. It's not being talked about much. Everybody doesn't know much about it, but it's just arbitrarily there. And I've talked to parties on both sides that seem they're quite sure it was arbitrarily put in, even though they were opposed to it. So I know it was part of the issue that the petitioners talked about. Now, whether it was addressed or not, I don't know anything about that. But I would like to know if there's any other jurisdictions in the state of Washington that do what Thurston County is proposing.
Ty, do you have anything?
Yes. So Travis, you mentioned the co-designation could be appropriate if there were, you said, detailed findings regarding a specific conflict and findings about the long-term commercial activity that has priority. And we have co-designation now of agriculture, or sorry, we don't have co-designation. So do we have these findings that you're describing now with regard to agriculture to justify the lack of co-designation, or is that just not gone up to any, legal challenge? And we need to add them if we're going to continue this policy that we have currently, is my understanding.
Well, just to clarify, I think it does get confusing. You need those findings if you do not have co-designation. And I think you're correct that the current ag sections do not have code designation. Whether or not we have findings, I don't know. I'd have to look at the record. I think those ag updates were done, I don't know, sometime after 2005. Jennifer and Maya obviously would know better, but yeah, this is a long-winded way of saying I don't know. I don't know what the basis for those updates were. I just don't have the record in front of me. But
Okay, well,
whether they're up for consideration in the future is another complicated question too.
okay, well, and this question probably is getting ahead of the presentation, but in addition to the current policy and why ever that was done in a time before any of us were here, my understanding from the presentation on October 1st is that staff had recommended not to co-designate. So are they, so I'm just so they must have had a rationale, and I assume they were in collaboration with you and knowing kind of what the legal requirements for that recommendation would be. Is that accurate, or is that going to be covered at some point later?
So staff has been in discussions with Travis on this issue for sure. And we do have information on file that would help support specific findings that we would then bring forward. And this would be something that would be after public hearing, depending on what options you sent forward to public hearing. But one option would be you hold the public hearing on all of the options, co-designate, not co-designate. We could bring forth those specific findings, and that would be part of the action that the board would take in terms of folding them into a resolution if you chose to not co-designate. So it's something that we're prepared to bring forward. I think we're still working on them somewhat to understand the level of detail that we would need if at the end of the day we would not co-designate. So we're prepared with information to bring forward.
Thank you. That answers my questions for now.
I have one more on that 1,000-foot, and I don't want to get stuck or get lost in terminology or legal terminology. The 1,000 feet that we're talking about was not challenged, I understand. But is that, Commissioner Everett called it a setback. Is it a setback, or is it a buffer? Or is buffer different than separation? Is buffer different than setback?
It is not a buffer or a setback. It's applied to the map. So it's a criteria that essentially is saying these areas are potentially incompatible for land use and mineral lands. So designation is the first step. We create this map, and that's where the 1,000 feet is applied. A setback or a buffer would occur in the county code. That 1,000 feet setback is not in the county code. It's applied to the map. So there are additional criteria in the code that determine what the setback for a mineral extraction operation is from a property line. I believe it's 150 feet, but the 1,000 feet is really applied to the map. It's saying that this area is not a designated mineral resource land, and therefore it's not a priority area for that resource use specifically.
Okay. And then was that 1,000 feet then put in to protect parks or prairie?
So the 1,000 feet has a long history. It was included, I believe, in the original criteria for as a distance from urban growth areas. So that has been around the 1,000 feet from urban growth areas since, 93, I think. The parks piece, so 1,000 feet from parks and public preserves, was added in 2010. And that language was added for protection of parks in those areas.
So we being the county, Thurston County has a policy of protecting parks, but not a code to protect parks.
It's at the designation level. So it's the designation states what areas are generally compatible between the land use patterns and mineral resource as an industry. So that criteria is essentially saying that that area is not highly compatible for that resource use area. We don't want to, we don't want to prioritize resource use within that 1,000 feet. So I will go over some options that staff developed at the direction of the board back in 2018 that allow for some flexibility of what can occur in that area. But it was originally included because the county did not want to designate that area as a priority for that resource use specifically.
Okay, because I've talked with several people on about 4 different sides of this topic. And I've got notes all over on this. And I'm hearing that we don't have a code to protect parks, but you kind of explained that. That's been our policy, but I'm told the code is very strong protecting against mines. Is that an accurate statement?
The code is strong protecting against mines.
Against mines or mineral lands or mining?
I don't know that I would.
Subjective?
I think that's a subjective statement. I'll go over some of the details of the code language today, and that'll help you familiarize with some of the options that are being proposed and what that means. So.
Okay. Thank you, Maya. I'm ready to continue.
Hutch, I got to follow up then, please.
Go ahead.
Okay, I guess now I'm a little bit more confused. It's not a setback, but it's not a setback, but it's not in the code. It's only in reference to the map. Is it just in case the map isn't right and that gives a bit of a area to question? It's still mineable if there's product there to be mined, but it's only the designation on the map? Can you help me clarify that, please?
Yeah.
Is the map wrong or possibly wrong?
The map is based on geology and it's based on the best available science. So it's the best that's out there right now. That being said, it's a very high level view of information. So it's not perfect at the site scale or at the parcel scale. And there may be areas that do have resources that aren't mapped, or that don't have resources and are mapped. But the map is the best information that we have right now. The 1,000 feet is applied to the map, and it's stating that 1,000 feet within urban growth areas and that 1,000 feet within parks and preserves is not considered an area of compatible land use with mineral extraction. It's stating that should not be a priority area for mineral resource use. Historically, the county has not allowed for mining unless it was designated. So you'll see some options today that require a property to be included on that map in order to apply for a mining permit. However, some of the options we're proposing allow for some flexibility, including within that 1,000 feet distance, saying that we recognize that this is not designated, but an operator could still potentially apply for a permit in that area if they meet certain conditions. So this is a diversion from what the county has done historically. Historically, you did need to be designated in order to apply for a permit, but we're considering some new options going forward that would allow for some flexibility, including within that 1,000 feet.
Oh, okay, but still, it's on the map, but there is no code that addresses that, or does the code refer to the map and thus it does become part of the code? I guess where I'm going with this is, and this is probably one of the benefits of being a senior citizen here in the position I'm in, is I'm aware of gravel mines, gravel resources, including those that the county purchased a lot of gravel out of from the property owner to build roads and utilize for county purposes, but yet those mining locations do not show up in the so designated map. So, I mean, there's a history of a mining operation going on there many years ago, and maybe including recently, just once in a while or something. And I'm trying to figure out where the authority is to stop a citizen from using a resource that he has if it's not in the code. But if the code refers to the map and the map designates the 1,000 feet, I would say that it's in the code then, even though it's not drafted in the verbiage of the specific code if the map is referred to. So I don't even know. I'm kind of confused about it myself, and I'm trying to ask the question, and I know others are confused.
You're on the right track. I'll go back to what you said at the beginning of that, was that if the code references the map, then therefore the map is included by reference. Right now, the code language says that you must be designated on that map in order to apply for a permit. So yes, in that instance, you could say that the code is therefore referencing the map. You must be included on that map in order to apply for a permit. However, the county is proposing some options that would say, even if you're not on that map, you could still potentially apply for a permit. And that's where the diversion comes in some of the options that we're proposing. So.
Also related to that, I believe the code, I think the code doesn't apply to the grandfather in permits that have been issued for gravel mining. If those permits are within the 1,000 feet, this action the board could take will not take away that permit.
That's correct. So anything that is an existing operating mine is protected. They're still allowed to operate. And there are a couple of other types of uses that aren't captured in this. For example, mine for forest practices permits for under DNR forest lands, or a private citizen wants to extract gravel on their property for a driveway. That's not considered a commercial mining operation. So this code and this change in this map is really for commercial mining permits. Big operators that want to come in, move a lot of gravel, and need a DNR permit are captured in this.
Harold, thank you for that question, because that was one of my questions I had about grandfathering in existing permits. And I'll just reiterate what you just said, Maya, and I brought it up earlier, that a designation does not equal a permit. And when somebody actually goes through a permit, I'm actually told it's going to cost upwards of $750,000 to get to that point, because they still have to go through all the processes, EIS, everything to get to that point. So there's still protections in place. Okay. And I would imagine, just final comment, that Kevin Hansen, our hydrogeologist, has he done a lot of work, extensive work on this as well?
Yes, he was involved on some of the updates to the hydrogeologic code, and those are included in the proposed changes. They're not an option. They've just been updated and refreshed, and the stakeholder group was involved in review of those as well. So,
thank you, brilliant. We're very fortunate to have him. Okay, any other questions?
Yes,
we move on?
Yes, I need to find out a couple answers here, real just quick.
Okay.
A permit. How long is a permit good for if a permit is issued to someone?
that's a great question. I don't know that there's necessarily an end date on a permit once it's issued. As long as an operator moves a certain amount of gravel every year, or I think it might be every 3 years, I'm not sure the exact criteria off the top of my head, then that permit stays active. And the county requires a permit that's reviewed every 5 years. So currently there's a 5-year review for the county permit. And then I believe the DNR permit to do surface mining requires that a certain amount be moved every couple years. So as long as they move a certain amount of gravel or bedrock, then that permit can stay active.
And what is the designation of an operating mine? What constitutes an operating mine?
An operating mine would be something that has an open permit and meets whatever that criteria is to move a certain amount of gravel every couple of years. So There are potentially a couple of mines out there that are not actively pulling a lot of material out of the ground. They might move a little bit every few years to stay active in the system, in the permit system. And potentially, I don't know the reasons for an operator doing that, but I've been told that that does happen. So that is something that operators can do to keep their permits open. That would constitute an operating mine.
You did mention that, this is mainly designed for commercial operations. And I'm wondering about those individuals that, say, have sold a product to the county for their projects. Did they need a permit to do that? Or if the county's buying something from a citizen, does that become part of the process as a permit? I mean, would that set a precedence, Would it be grandfathered in?
Yeah, I don't know that it's based on sale necessarily. It's based on how much material is being moved. So the amount of material and the acreage that's being moved is really what triggers that threshold.
And just maybe to clarify, the county will not purchase any materials from somebody who is not licensed and permitted to provide those services to the county. So if it's an organization of an individual, they have to be permitted before the county can exercise purchasing any materials from them.
Okay, we're 35 minutes into this. You have 17 more slides to get through.
I think I probably have more than 17, but let's go ahead and
Okay.
maybe we'll answer some more questions as we go through the PowerPoint. So recent history, this update started in 2017 when the board adopted a scope of work, and that scope of work said to designate mineral lands and update the map based on the existing designation criteria. The county kicked off that review with a stakeholder group and also planning commission review, and the planning commission did a lot of work on that from 2017 until early 2018. A public hearing was held with the planning commission on the scope of designation in early 2018, and at that time the planning commission recommended to stick with the current scope of work, which was to map the existing criteria, but to also consider co-designation of mineral lands and ag lands. Then staff took that recommendation to the Board of County Commissioners in May, and from May to July, there were a series of discussions that led to, in July of 2018, the majority of the board directed staff to proceed with that recommendation, which was to map the current designation criteria, but to also consider an option that co-designates ag lands and mineral lands, but to also look at policy language that considered partially designated parcels and allowed for some flexibility in the 1,000 feet. So the options that I'll be presenting today meet that request to address partially designated parcels and allow for some flexibility of operators in that 1,000-foot area. In May of 2019, the periodic update was split into core and continuing, and this was done in an effort to get the required elements through to adoption, but to also allow for additional time for public input on a number of other continuing items, mineral lands being one of those. And then in November of 2019, the county adopted the core items of the comprehensive plan. And that was the big update that was done at the end of last year. That update satisfied the county's overdue periodic requirement. So we have satisfied that periodic update requirement. Now the county is just working on those continuing items that needed more time for public review, and mineral lands is one of those. So 2020 has been a focus on those items. So now we're going to get into the fun stuff, and soon I'll be talking about options, but I just want to go over some state guidance on mineral lands and how it is designated. So mineral lands is guided by the Natural Resources Goal in the Growth Management Act, and that goal says to maintain and enhance natural resource-based industries, which includes timber, agriculture, fishery, and to encourage conservation of those lands. There's also guidance in the WACs that says successful achievement of that goal is achieved by requiring conservation of those lands. So that is the goal of designation, is to achieve conservation of those lands over the long term. There's also some guidance under the Washington Administrative Code on minimum guidelines to consider when designating mineral lands. So some of the criteria that the state suggests should be considered is geology, projected lifespan of the resource needs of the community in the region, accessibility, and general land use patterns. Are general land use patterns consistent with resource extraction? So the county has considered these guidelines in reviewing our existing designation criteria, and generally the county criteria are very well aligned with the state guidelines that are in the Washington Administrative Code. So project steps for this update. The mineral resource lands update kicked off in 2017, and the first step to that was to identify and classify mineral resources. So back in 2017, the county hired a consultant to complete an inventory, and that mapped all of the mineral resources across the county based on existing geologic information. And that map was adopted back in November of 2019. So last year, the county did adopt that inventory map, and that is the basis of the Mineral Lands Project. The second step is to designate. So this identifies where priority resources exist, and they're generally compatible with existing land uses. This is the criteria that's in Chapter 3, and this designation step, this step number 2, is essentially the map, the creation of the proposed map that's before the board today. The third step is the conservation phase, and this step identifies policies both in the comprehensive plan and also in the development code to help conserve resources and protect them from future land uses. And then there's this fourth step that is not part of the comp plan update, but it's still relevant. It's the permitting phase. So every new mining operation or expansion of a mining operation, if it's a commercial operation, still needs to apply for a permit with the county before they can do any mining. As Commissioner Hutchings mentions, just because they are on the designated map does not mean that they will automatically get that permit. They still have to go through that permit process and meet all of the other code requirements in the Thurston County Code. So not all designated areas will ultimately be eligible for extraction. There might be critical areas or other types of land use constraints that exist that are applied at that permit phase.
Maya, could I get a question there from you?
Sure.
You know, Commissioner Hutchings said something about it could cost $700,000 to get a permit to do a mine. Is that, where does that number come from? I'm just kind of curious. That seems like that's not very conducive to helping businesses be successful in our community and creating jobs. Could you just kind of clarify that for me?
Yeah, so I don't know off the top of my head what a ballpark cost for a mining permit would be, but part of the reason there's such an expense associated with that is because it's not just the county that permits for these operations. They also have to get a permit for discharge through the Department of Ecology. They have to get federal permits. They have to get state permits through the Department of Natural Resources. So there are a lot of components that go into opening a mining operation. And all of those permits together cumulatively adds up to a significant cost to open a new operation.
And the number I got was 750,000 and considerable time because of all those federal, state, and local requirements. And that was given to me by a person in the industry.
Yep, these permits do take quite a long time to ultimately get to a place where they're in action on the ground. That's not necessarily the county's fault. It's just there's a lot of different permits at all levels, local, county, state and federal that go into opening a new mine. So
All designed to protect, I would imagine. And you say, like you said in that previous slide, policies that ensure compatibility between resources and future land uses. Okay. So go ahead. We're getting pretty close to the options.
So major changes related to the mineral lands update. There are some changes in Chapter 2 to the land use acreages, and these just account for the change in the map. Chapter 3 has a lot of changes in the policy language and also an option associated with a change to the designation criteria. And then the big one is the map. So map M43 is the current map, and that will be repealed and replaced with the proposed map, map N2. There are also 6 sections in the county code with proposed changes. Those range from mineral extraction code, just definitions, and then 2030B is the zoning code that applies the designated mineral lands overlay. There's some other smaller sections like the special use permit section, and then 2060 we're proposing a name change to that section, which is another docket item. So going into the options, we are at the point where we can visit that. So there's 10 separate options that are related to mineral lands, and there's 4 main decision points for those. I'm going to go through each of these by the decision point, and then I'll explain what the options mean and give the board some examples of what those would look like if they were applied. You'll see on...
Maya, I'm sorry to interrupt. It would be better for you then to get through all the options and decision points and then hit you with questions.
Yeah, I think it might be great if the board wishes to write down their questions and we can go over them at the end. That might get through this a little bit quicker if everyone's okay with that.
Thank you, I am.
Yeah. So you'll see on this chart that there is no decision point B. That's not a mistake. That point was previously included early in the Planning Commission review, and through the stakeholder process and also through the Planning Commission review, the stakeholders and all of the folks came to some sort of an agreement. So those options were removed, and that language is just proposed as an amendment. It's no longer an option. So starting off with decision point A, this is our current map in the comprehensive plan of what mineral resource lands looks like. It only designates existing permitted mines, and it's roughly about 5,000 acres. But this is not the criteria that's in the comprehensive plan. So we are required to do it countywide based on geology, and that is not what this map does. So this is one of the big things that's being updated in this. So in updating that map, there is decision point A. This looks at the map options and also the designation criteria in Chapter 3. And these 2 options stem back from 2018 based on that Planning Commission recommendation and further board direction at that time. So option A1 maps the existing criteria that's in the comprehensive plan. There's no changes to that designation criteria, and that ends up mapping, when applied, is about 140,000 acres of designated mineral resource lands. This option does not currently co-designate long-term agriculture and mineral resource lands. That's roughly 2,100 acres that are not included in this. And it may limit the flexibility of farmers that have mineral resources on their property by not co-designating. So that is one consideration of that option. The second option is a diversion from our current criteria in the comprehensive plan. And that option has one change, which is to co-designate mineral resource lands and agricultural lands. That's roughly around 2,100 acres additional. So that maps about 142,000 acres. Option A2 is consistent with GMA guidance that says that overlapping resource areas should not be considered inconsistent. However, this option could temporarily impact the long-term agricultural land base. So we talked a bit about this earlier with Travis, but just to keep in mind the GMA guidance on overlapping designations, I did want to throw this up here. the third bullet point down that says if 2 or more natural resource land designations apply, counties and cities must determine if these designations are incompatible. If they are incompatible, counties and cities should examine the criteria to determine which use has the greatest long-term commercial significance, and that resource use should be assigned to the lands designated. So it does not prohibit the county from not co-designating areas, but there is a higher bar that the county would need to meet in providing findings as to why those areas are not compatible and which is the area of greater long-term commercial significance. Also, the bottom bullet point on this slide highlights that mining must be considered temporary. So after mining is complete, other uses can occur on that site. So looking at the A options, this map shows both option A1 and A2. This is the proposed update, and this would be map N2. It's based on geology, and it applies those designation criteria countywide. And the old map, roughly 5,000 acres, goes to this proposed map when that criteria is applied. So the 2 options, A1 is the current criteria. That's the lighter areas on this map, the lighter blue and the lighter orange. And then A2 is the darker areas. So you'll see right above Bucota, there's a little bit of darker green. There's a couple in the central part of the county of darker green. And then the southeast part of the county below Rainier and Yelm. Those are additional lands that would be co-designated under IA2. It's about 2,100 acres that would also be co-designated because those are areas of mineral lands and agriculture. This was a request at the last briefing to show that mineral lands designation over the agriculture overlay. So the green areas are the county's current long-term agricultural lands. And you'll see that most of the areas that would be co-designated are kind of on the fringes of those long-term agricultural lands. But again, roughly 2,100 acres. We have about 15,000 acres of long-term agriculture in the county. I just want to check in, Scott, do you have anything to add on the Planning Commission's recommendation to go with A2 that might provide the board some insight on the Planning Commission's recommendation for that?
Oh yeah, I've got plenty. I think the first thing to notice, and I will say, Commissioner Edwards asked about who was here before. I was here when the Thurston County Planning Commission did the original. And as far as the 1,000-foot buffer, I will say, in my opinion, it is arbitrary because I don't remember us ever getting any science to back that up. As far as co-designating, the biggest thought I have on this one is ag lands are, by definition, because they're zone 1 and 20, larger parcels. And those may be 20, 40, 60, 80, even bigger parcels. And the definition of ag land is majority prime soils. So if you've got a 40-acre parcel, you could have 19 acres of a mineral resource on that parcel and 21 acres of ag land. So I think that, to me, that's the biggest thing, is we're telling people you can't mine quality agriculture or quality mineral lands because there's ag land here. And the other thing I think I will say, that my family farms near mines. I'm one of the people in the county that says miners make great neighbors, because 90% of the time they show up at 6, 7, 8 o'clock in the morning and they're gone by 5 o'clock. So they don't have any complaints about whatever I am doing, running my tractors after dark. I would also suggest that they would probably say the same about my family. We're probably as good a neighbors as they could ask for. And part of that's because of how it used to be. You know, we know all our neighbors. So if we have a problem, we don't call the county. We go and talk to them first. And I can't think of anything major that we've ever had, but it's always been anything's always been worked out. You know, I think back to long-term ag, excluding long-term ag simply because it's long-term ag doesn't make a lot of sense to me. You know, for some people, that could be a way to save the family farm. And do we want to cut that out of them? The other idea that I had was a few years ago, we were trying to do some work on our property, and NRCS came in with a drill rig and drilled on our long-term ag ground. Now, he could only get, I want to say it was 10 or 12 feet. He could not find gravel in the distance that he could drill. So for those of you that have talked to miners, I'd like you to ask them, you know, how far along do we have to get in depleting our resources for it to be viable for you to dig 5, 6, 10 feet of topsoil away before you get to a mineral resource?
Okay, Scott, are you, do you have ag or farm or mineral? What do you have?
Well, we have long-term ag land.
Okay.
I haven't looked. I'm sure based on where I live that we have land that is going to be designated as mineral resource. I do not believe that we have any that would be co-designated as both. But there's another one I'll point out.
Just real quick, go ahead.
It's now Deschutes Ag Resources, but it used to be the Johnson Pit. There's an example of what I'm talking about, where part of that property is designated as long-term ag. But if you go look at where they've dug, they haven't dug into good farm ground. They've only dug into gravel ground.
Okay.
And all the farm ground is still there. And that has allowed the Johnsons, well, they've sold it now, but until Lynn, who was my dad's age, died, the Johnson family was able to keep that land in ag production
Okay.
for a lot of years.
So you, and I don't mean this derogatorily, but you have a stake in the game then as to what happens here, what options are chosen?
I actually don't think I do. Like I said, I don't think, and maps like this are all I've seen. So we haven't gone in and looked real close at, as a planning commissioner, we haven't gone in and looked at parcel by parcel designations. We've only looked at overviews. And like I said before, I think that whatever you do, part of my farm is part of my family's farm is going to be now designated as sand and gravel, which I think anybody that's ever driven by my family's place would not be surprised about that. I do not think that any of the ground that we have that's long-term ag is going to be included on that list. And if it is, it's a pretty small parcel, or it's the same thing that I was just talking about, where it's part of the parcel is good ag land and part of the parcel is good mineral resource land. And I can tell you that part of that reason is on my family's...
Make it quick, Scott. We got to move on.
My family's south side is a gravel pit and the old county pit. To the west of my family's farm is the Johnson/Deschutes pit. And to the north of my family's farm is a pit owned by Dan O'Neill and Sons.
Okay. Maya, continue on. Thank you.
Great. Thanks, Scott. So moving on to option C, this is the decision point for the resource use notice distance for plats. And currently, plats require a 1,000-foot resource use notice, and the state law requires a minimum of 500 feet. So there's two options proposed here. Option C1 maintains the current language. This is already being implemented. So all plats within 1,000 feet of designated mineral resource lands have to file a resource use notice. This maintains the current county code language. It's in compliance with state law. And just a bit of history for this, the board in 2003, the board at that time changed the resource use notice for plats from 500 to 1,000 feet. So previously it was 500. They upped it to 1,000 feet in 2003. The second option was developed just based on stakeholder feedback as a possible alternative. That reduces that resource use notice requirement to 500 feet. So that lowers the distance. However, it's still compliant with state law and consistent with that requirement. We didn't receive significant public comment on either of these two options. So there was not a lot of public comment either way on these two options. And just looking at code language, again, option C1, 1,000 feet, current language that's already being implemented in the county code. Option C2 reduces to 500 feet. This is a change to the county code, section 1804. So I'm going to gloss over that one since that one didn't receive too much public comment. And now moving into option D and option E. So these are the two decision points that have received quite a bit of public comment. I know the commissioners have been hearing from the public about some of these. Option D is what we as staff have been referring to as the expansion policies. And these three options determine when mining can occur on undesignated lands. Again, we're talking about commercial mining permits. So option D1 is the tightest option, and that only allows for expansion and mining on designated mineral lands. So property must be included on that blue and orange map in order to apply for a permit. This is the easiest to implement. However, it's also the least flexible to the industry because it limits permitting only to those blue and orange areas. Option D2 is a alternative, and this is a diversion from what the current county currently does. This would allow for operators that are currently in existence to apply for an expansion onto an undesignated land. So an operator, as long as they're on that map already and they're existing and they're operating and they're moving gravel, they could apply to mine on an area that's not included in that blue and orange, including within the 1,000-foot area from a urban growth area or park. And this option was really developed to encourage and allow flexibility for existing operators to expand. There has been a point brought up in those stakeholder group meetings that expansion is less environmentally harmful than the creation of an entirely new mine. So this really allows for flexibility to existing operators. It's a moderately easy to implement. It could be done by our permit staff. It allows for some flexibility to the industry. And then the third option was developed earlier this year. It was added a little bit later in the game when the Planning Commission directed staff to take it back to the stakeholder group. So we convened a smaller stakeholder group and worked through to create option D3. I do want to note that not everything in this option that group came to agreement on, and there are some points in here that the folks that were at that table did not agree on. So primarily, some of the stakeholders did not agree on allowing for expansion into the 1,000-foot from a UGA or a park. Specifically, a park was the big point of contention there. It's the same as option 2, but it allows some additional flexibility. So it also allows for new operators or expanding operators to go within that 1,000-foot distance from a park up to an existing barrier, and a barrier being a road, a railroad, or an industrial use. It would also allow for a new or an expanding operation to go within 1,000 feet of a park if that park was donated by a mineral extraction operator. The onus of proof would be on the operator to provide proof that it was donated to the county or whatever other jurisdiction as a park. Mines in the urban growth area could also expand outward into the undesignated 1,000 feet in this option. So option D3 is the most flexible to the industry. It's also the most difficult for our county permit staff to implement because it has a lot more exceptions to the rules. So you start getting more and more exceptions of when certain operators can apply outside of the normal criteria, and it becomes a little bit more difficult to implement at the permit level. So these are the 3D options. I do want to note that we've received some public comment from citizens, both on the industry side and on the environmental side. Some citizens are requesting that the board direct staff to include an additional D option. There's also been some comments that support the Planning Commission recommendation of option D3. So you've heard from both of those sides. Again, this is a change to 2030B. You have your 3 options. Option D1 is the least flexible to the industry. It only allows it in the blue and the orange area. Option D2 allows for some flexibility outside of that blue and orange area if you're an expanding operator. And option D3, in addition to allowing some flexibility if you're an expanding operator, also allows for new mines up to a barrier or when a park was donated. So I'm going to go through some homemade examples of what that looks like. These are pretty simple drawings, but here's an example of D1. So we have an existing mining operator here on this orange property, and you have some designated mineral lands right to the right. These are supposed to be parcels, these squares here. So this operator wants to expand. And if option D1 was in place, this operator could only expand onto the parcel with the designated mineral lands. They could not expand north because that parcel doesn't have any designation. And there's also a 1,000-foot separation distance, which is this red line. And they could not expand to the left, which is also not designated. So they're really limited to only expanding onto properties that are in that map. Option D2, this is the option that allows for expansion of existing mines onto undesignated lands, including the area that is within the 1,000-foot distance from a park or preserve. So let's just say everything above this red line is 1,000 feet from a park. And we have an existing mining operator, again, the brown, and he wants to expand his mining operation. So if option D2 was in place, this mining operator could expand on any of these 3 parcels that are adjacent to his current mine. That operator could expand on the designated mineral lands. They could also expand on the property just above it, including the area that's within the 1,000 foot from a park, or they could expand on the property just to the left of it, which is undesignated as well. So it allows for some flexibility. If this was a new mine, they could only apply on the mapped area still. So D2 really allows that flexibility for expanding operations, not for new mines. And option D3, so what I just went over would also apply. You could still expand, but it also allows for some flexibility for new mining operators. So let's say we have a new mining operator and they want to apply for a permit. I changed the parcel here. So they want to apply on the parcel just above them, and there's a railroad, and it's also 1,000 foot from a park. So that new mine could apply on that parcel, including the 1,000-foot distance from the park that is up to an existing barrier, which in this case is a railroad. If the park was donated, they could also apply on that property. They could also apply if this was an urban growth area and that was within the 1,000 foot of the urban growth area they were moving out. However, they could not apply on other undesignated lands in the counties. There's really only a few exceptions where they could apply on undesignated lands, and that's when a park's donated or if there's a barrier that's in place from the park area. So those are my simple attempts at trying to illustrate what this might look like in implementation. I'm going to move on to the E options. And the E options really get down to how the map is interpreted at the site level. So again, the map is based on geology. It doesn't conform with parcel lines. So there might be some parcels that are halfway cut through with mineral lands, or they have a little spot of mineral lands on them, but the geology doesn't conform to the parcel line. So how do we implement that when someone comes in for a permit? Well, there's 3 options that attempt to get at that. Option E1 requires a double threshold designation. So in order to be eligible to apply for a permit, property must have at least a 1/4 acre and 5% of mineral resource lands mapped on it in order to be able to apply. That operator can also apply if it meets that criteria and there's an undesignated area within the 1,000 feet, then they can apply for a permit on the whole parcel, including that undesignated area within the 1,000 feet. This is a little bit more difficult to implement, but it does allow for some flexibility to the industry, and it's practical in terms of permitting to have that dual criteria of at least a 1/4 acre and 5%. A little bit of history about where the 1/4 acre and the 5% came from. So back in 2018, we had some discussions with the stakeholder group, and the industry said that about a 1/4 acre would be the minimum amount of minerals needed in order to make a viable commercial operation. That is where the 1/4 acre came from. Option E2 requires any amount of a parcel to be designated, and then that whole parcel, including any area within 1,000 feet that is not on the map, is eligible to apply for a permit. This is the easiest option to implement, and it also allows for the most flexibility to the industry. Again, the map is not perfect at the site level, so this allows for a lot of flexibility in that for operators to apply. Maybe mineral lands may not be mapped. Finally, there's option E3. This option requires that all of a parcel must be designated in order to be eligible for permitting. So you could have 400 acres, and if 399 acres are designated under option E3, you can't get a permit on that property. So this is the easiest to implement, but it's the least flexible to the industry. There's not a lot of fully designated parcels out there in the county because it's based on geology. So this does add quite a bit of limitation. It cuts that 140,000 acres into about half when that's applied. It comes around 70,000 acres of land that meets that criteria. Just to note that we've also received some public comment on this, again, from both sides, industry and environment. Some folks have commented that they're in support of the Planning Commission's recommendation, which was option E2. If any amount is designated, the whole parcel is eligible to apply for a permit. And we've also received some comments from citizens that are requesting the board direct staff to include a different option, something similar to E1, but that looks at different metrics. So staff could absolutely consider that. I can get into what that would mean at the end of this presentation. So just some examples. Here we have a 5-acre parcel, and it has 1/10 of an acre mapped as designated. There's also a 1,000-foot separation distance, which is any area below this red line. So under option E1, could this parcel apply for a permit? It could not, because it doesn't meet the minimum criteria of a 1/4 acre mapped. So this parcel couldn't apply for a permit. Under option E2, is any amount of the parcel mapped? Yes. So this whole property, the entire square, including any area within that red line, could apply for a permit because it has any amount mapped. Option E3 is the whole parcel mapped? No, so not eligible for a permit. Here's a second example. We have a 400-acre parcel, and this parcel has 5 acres mapped as designated. So under option E1, the double threshold designation, could this parcel apply for a permit? Yes, it could. It doesn't meet the 5%, but there is an additional criteria that says if at least 5 acres is designated, then the whole thing can apply for a permit. And that comes from the current designation criteria, which has a minimum site size of 5 acres. So that is where that specific component comes from. Option E2 says if any amount is mapped, then the parcel is eligible for a permit. Oops. Yes, this parcel has a little bit mapped, so the whole thing would be eligible, including the area within 1,000 feet. And under option E3, again, this parcel is not completely mapped, so it would not be eligible. One last example, this whole parcel is mapped, it's 10 acres, it's all mapped as designated. On this case, both option E1 and E2 would apply. This is the only situation where a parcel would be able to apply for a permit under option E3. So option E3, again, is the least flexible to the industry in that it requires an entire parcel to be on the map in order to apply for a permit. So just as a refresher, I covered this at the last briefing, but the Planning Commission recommendation was to, specific to mineral lands, to include options A2, C1, D3, and E2. Just to go over that again, A2 is the co-designation of mineral lands and agricultural lands of long-term commercial significance. Option C1 maintains the current language for plat resource use notices of 1,000 feet. Option D3 is the stakeholder developed option, although not all stakeholders were in agreement of that option, that allows for expansion of existing operators onto undesignated lands, including within that 1,000 feet from an urban growth area or park, and also allows for new mines to apply on undesignated lands when there is a barrier in an area from a park, or when the park was donated by a mineral extraction operator. Option E2, which says that if any amount of a property is designated, then the whole parcel is eligible to apply for a permit. And the F option, which is associated with the forestry, I won't go over that again since we're mineral lands focused today. Just to hit on where staff's recommendation differed from the Planning Commission recommendation, staff did recommend option A1 before the Planning Commission, and the reason behind that recommendation was primarily the public comment that was received. So there was a significant amount of public comment received in favor of option A1, and also that the county is currently processing a separate docket item that is a community-driven review of agriculture, and there may be additional information that comes out of that review of agriculture that further informs this co-designation discussion. So that is the primary reason for the difference there. Staff is sensitive to the other policy work that's ongoing with the county and how that could potentially impact this consideration. Staff also differed on the forestry option. Again, I won't cover that, but the gist of that was that staff was sticking with the status quo on that option where those parcels are currently zoned as long-term forestry, and staff recommended not diverting from that because of the small amount. So next steps, just to go over the 2 steps and options before the board. Again, staff is looking for any additional information, questions, follow-up that the board needs prior to directing staff to set a public hearing. 2 options before the board. Option 1 is an attempt to keep the comp plan on track for an adoption at the end of 2020. That would require directing staff to set a public hearing on October 27th, and that public hearing be held on November 24th. Again, that would keep us on track to have these updates adopted by the end of the year. Option 2 is if the board wants to dive a little bit deeper into this and request additional briefings, if the board would like staff to look into developing any alternative options prior to a public hearing, that would fall under option 2. That would likely mean that adoption would be pushed into 2021 because the county can only amend the comprehensive plan once a year. So we would continue review of this in 2021, and then the final adoption would occur at the end of next year. So that concludes my presentation, my very lengthy presentation. Thank you for letting me get through it, and I'm happy to take questions now.
I'd be shocked if there were any questions.
Yeah.
Go ahead. Let's start with Ty. Go ahead, Ty, if you have questions.
Okay, going back to the D options. I need a little more explanation as to kind of the importance of these different variations, because I guess if are we assuming that because you said at the top of the presentation, you said the map is based on best available science, but it's not perfect. Is that the underlying driver behind why we're so worried about mines being able to expand onto undesignated parcels? Because if the map was perfect, right, you would never have that situation because there's no minerals where the parcel's not designated. So is this all predicated on the notion that the map is just not accurate and there's going to be like tons of situations where I'm mining here, but I find out that there's an opportunity to mine next door?
Yeah, so my response to that question would be no, that these options were not developed based on that, because even if there are minerals within that 1,000 feet, they will never be designated based on the existing criteria, because the criteria says that any area within 1,000 feet of an urban growth area or park, even if there's minerals there, even if there's high quality minerals there, it's not designated because it's not generally compatible with that land use. So the options D2 and D3, they divert from our current process. Currently, we only allow mining on designated areas. And the development of those options is primarily, one, to allow for expansion of operators and to allow flexibility and expansion, to encourage expansion over new mines. And two, it was developed because that was the direction of the board that was provided in 2018. The majority of the board at that time provided direction to staff to look into some alternates that allowed for flexibility within that 1,000 feet.
So this goes to the second thing that you were describing, about how it's not that the 1,000 feet is a removal from the map, and therefore we know there's minerals there, but they're not mapped. They're not designated because this is an application that we apply to the map.
Mm-hmm.
But you also, in your little hypothetical pictures, you had options to expand, outside the buffer. I mean, it wasn't just limited to going across let's call it a buffer just for terminology. It wasn't just expanded to going over the red line. It was also going there to the left.
Yep.
So
and
why would I want to go to the left?
And that does hit on what you mentioned about the map not being perfect. So allowing it to go to the left here, a mining operator is not going to apply for a permit unless there's resources there. And it's possible that it just didn't get mapped. Maybe that data wasn't available, it's not perfect. So that does hit on what you mentioned in the map not being perfect. But the 1,000-foot flexibility, as I mentioned, there could be minerals there. They're just not mapped because of the criteria.
Are you hearing from industry that there are a lot of situations like the one, like moving to the left in a non-buffer, undesignated parcel situation?
Potentially, I think it gets back to allowing for the flexibility of an existing operation to expand, as opposed to requiring them to create a new operation. These operators sited in these areas before we had this countywide map, so it really gets to allowing them flexibility to expand. If there's an area that's not included on the map, and it should be, and it meets all of the designation criteria, so it's a parcel bigger than 5 acres, it has minerals, and they can prove it based on boring samples or whatever it may be, it's not within 1,000 feet of an urban growth area or a park, someone can come in and apply for a comprehensive plan amendment and say, we have geologic information that says your map is wrong, we want to be included on it, and they can absolutely apply for that. The option D2 and D3 just eliminate that step by allowing for the flexibility of certain expanding operators to do that without coming in for that comp plan amendment.
Okay, and then I'll jump to E. I guess my question is, how much, to me, there's a big me, there's a huge gap between E3, which is very, very restrictive, unreasonably restrictive. And then the next jump is all the way to E1, and E1 is, that's a huge gap. And so I'm guessing, you said there was some public comment about having a different E1, and I'm guessing, just based on my own perception of these two options, that those people were asking for sort of a stronger E1. Is that accurate?
Yeah, the comment that I received for E1 requests that, let's see if I can remember it off the top of my head, a minimum site size of 20 acres, and then the percentage to be, I think it was 40%. And that group mentions that they're not tethered to that criteria, that they would just like something stronger than what is under E1, and also to eliminate this allowing into the 1,000 feet from urban growth areas and parks. They want that criteria removed. So it's just the area that's not included in that. And staff could absolutely look into something different. I will say a 20-acre minimum site size is a little bit different than what we have here. This option really looks at how much mineral lands need to be mapped, how much needs to be on that map. It doesn't have a minimum site size. A minimum site size would be something that goes into a special use permit code. So there's a little bit difference in the criteria there, but staff could absolutely look into some sort of a revised version if that was the direction of the board.
And if the board directed that, what would be, like, given how much work you've done and how much time goes into these, and how much you already know about the various options, how much time would be involved to develop an alternative E1?
Yeah, I think I would, at a very minimum, that would need to get run through legal again, and I would need to look at what specific section of the code and speak with the folks who proposed alternative option. I'd probably want to have at least one more stakeholder group meeting, or get some sort of feedback from the broader group on what other folks' positions are on that, whether that's just an email that goes out or holding an actual Zoom meeting. I don't know, but it would likely delay. I would say any option that would require further investigation and legal review would probably push this review into 2021.
Okay. I'll cede to my seatmates for now.
All right. Based on just what you just said, Maya, is that because of a 60-day requirement as well, or 60-day notification that the county has?
We already did the 60-day notification to Commerce, so we would just need time to develop the option, figure out what section of code it goes in, draft that language up. The big piece that would probably add a lot of time to that is if this gets a little bit more feedback from the bigger mineral land stakeholder group. So the folks that have submitted the comment aren't the face of that entire group. We'd be looking for comment. Staff certainly doesn't have to send it back up to the stakeholder group. You could get that input from a public hearing, but that would be something that we'd consider if we were going to develop a new option. So,
okay. I've got a few more questions, but I'll defer to Gary Edwards. Go ahead, Gary.
Okay.
We have until 12:30.
12:30.
Okay, go ahead.
Maya, you made reference to there is a possibility, if the map is wrong, it sounds like that an applicant can challenge that if they can show there's resources available. Is that right?
Yeah, I wouldn't use the word challenge. Anyone can come in and apply to have the map changed to be included on it. So we have a list of what they would need to show. They'd need to submit an application for an amendment to the map, and they'd need to provide a geologic samples, and they could apply for that at any time for the county to consider, and that would go through the normal docketing process. There would be a fee associated with that. And then the county reviews that map every 8 years during the periodic updates. So there's a bigger refresher, even if we don't get people who apply, that the county looks and sees if there's any new data that needs to be considered, and does the map need to be updated on the bigger periodic update cycle.
Okay. Could you tell me how were the boundary lines of this map chosen? I guess I guess we didn't do it. We're using a geo map from somewhere else, but could you explain that, how the boundary lines were chosen?
Yeah, so this map, let me see if I can get my mouse to work. This map is based on geologic data, and it looks at a lot of different information. So anything that was in the DNR data, anything that was, I think the consultant looked at well drilling samples if minerals were found there. If an operator submitted during our public comment period for the inventory saying we're not on this map and we should be, then we added that in. And then the criteria that's in the comprehensive plan is overlaid that on to the original inventory that maps all of the geologic resources based on that DNR data and well drilling data. And it removes the areas of land uses that are generally considered not compatible in the comprehensive plan.
Would you say that the boundary lines are fairly exact and accurate?
It's based on geology, and there's not, I mean, the geologic information that's out there is not perfect. It's not that someone goes out to every single parcel and does boring samples. So no, it's not perfect. And that is part of the options recognize that this map is not perfect because there are not those site level samples on every single parcel. So.
And is that where the 1,000-foot thing comes in as far as that flexibility, recognizing that it's not accurate possibly to give folks some leeway?
Again, this gets back to Commissioner Mentzer's question. The 1,000-foot area is not included on the map, not because there's not mineral resources there. There could be resources there. They're just not mapped because that area in the current criteria is not considered compatible between the land use and resource extraction. Where the map being imperfect really comes into play is if the operator wants to expand to the left here and that parcel's not mapped at all. And maybe it's a mistake that it's not mapped at all. It's not because it's in that 1,000-foot area from a urban growth area or park. It's just not mapped because the geologic data wasn't perfect. That's where the flexibility in that option gets at. So,
would just as a from a surveying perspective, mm-hmm. is the boundary line between one area and another? Is it like 1 foot? Is it, how exact is it? I mean, how is it determined that we know where the map says, if somebody comes in and says, well, gee, that's not even in the right place, that overlay isn't there. I mean, is the overlay boundary, could it be like 100 feet, more of a wide line for flexibility? How do they come up with knowing that boundary line exists as shown on the map? I mean, how accurate is that? Because I look at our geo map once in a while compared to an aerial photograph, and sometimes it's off by 40 feet or more. Mm-hmm. So I'm trying to figure out how that fits in, that ability to be exact. How does that play into it? I mean, it could be, part of a boundary line adjustment or something that took place. I don't really know. I'm just wondering, how can we depend on this to be right? And that's why I'm trying to think about that wider designation of the boundary line, if you will.
Right, and you're hitting on two important pieces there. So the map is based on geology, and there is a margin of error associated with that. I don't know what it is off the top of my head. It could be as little as 1 foot. It could be perfect on some of these properties. It could be 150 feet or more. I don't know the exact number. But the second piece that you mentioned is sometimes you look at an aerial view and the parcel layer is just not perfect. The parcel layer is constantly changing. It isn't perfect. It's not perfectly aligned with properties, but this map is based on geology. So where the parcel layer shifts over this map is not going to impact what this map looks like. I don't know if that answers your question. This map is not based on parcels, it's based on geology. So parcel layer shifting doesn't impact where the geology is underlaying that.
If a citizen comes in and lays that out for you, it says, you know, hey, look at this, your own map doesn't even jive. Who's to say, is that something that could be fixed with a tabletop adjustment rather than going, you know, through the whole process to the rezoning, replanning? I'm trying to look for a simple solution for a citizen that might come forward with an issue, because I'm here representing the citizens. I'm not necessarily representing the government, although I want government to function properly. So who's to say on these type of issues? Is there some process in place? I know we're looking at allowing tabletop adjustments over there for other things. So would that take place in this case that I'm trying to lay out?
Yeah, so I think what you really get at is that adjustment, that flexibility comes down to the options that are before the board, those D options. D2 and D3 really allow for that flexibility if a property isn't mapped. And also the E options, E2 and E1 allow for that flexibility if a property isn't mapped. As far as coming in and changing this map, the option to do that would be through a comprehensive plan amendment. There's not something as simple as a correction that it could occur because it's based on geologic information and it has to meet a certain set of designation criteria, excuse me.
I guess, could there be some verbiage put in, let's just say D3. I understand D3 is what's recommended by the Planning Commission. So if we went with D3, I mean, could we as a board say, well, recognizing there's fluctuation on the potential of the map, if it's within 200 feet or something, the staff would be able to make that tabletop recommendation or bring it to the Board of County Commissioners for their review to make that change. I'm trying to come up with a simpler process for a citizen to do business without having to go through a $750,000 process that it might take.
Right. So I mean, staff could look into something like that. I don't know how easy it would be to implement an option like that because designation is a precursory requirement to permitting. But a comp plan amendment is a smaller amendment. Those range from $5,000 to $10,000, or a citizen can wait, and that would be included during the periodic update when we do a bigger review. So if they can provide that information and they're okay waiting until a bigger periodic update, then there's the possibility that we would just do the review and not assess a fee to them. So that's an option, to just wait till the county does a holistic review.
And I heard from Scott earlier that this 1,000 foot is arbitrary, and it didn't sound like he had any examples of best science or such. Did Jennifer come up with anything, do you know, as far as how that came about, the 1,000 foot? And if nobody else has done 1,000 foot, why are we putting 1,000? I mean, why isn't it 10 foot, 100 foot, 500 feet? I'm just curious.
You got that?
I think you're speaking to a legacy of a previous stakeholder process where this was a negotiated recommendation amongst a group of stakeholders some years ago that was forwarded through the Planning Commission to a previous Board of Commissioners who felt like they had enough information at the time to go ahead and implement the 1,000 foot exclusion criteria. I was doing some quick looking at the web, and this is just not totally complete, but I can't find 1,000 foot exclusion criteria jumping out from some of the counties I looked at. But I will say counties have a variety of criteria, including you have to have a 40 acre site size to be designated. And there's a lot of other criteria that other counties have applied to exclude from designation. So I think there is discretion on the part of the board to do that. Obviously, you'd want to have findings since this is an existing criteria, just to maintain it. I don't think that's as much of a lift, but to change it, I think we'd want to explore some findings for rationale of why to remove that 1,000-foot exclusion criteria. And that's something, again, like developing another option that staff could look into, and it would result in additional work and some delay of the ultimate bringing this to public hearing.
But the Planning Commission actually did submit as their recommendation D3. Is that right? Is that what I'm finally hearing out of this whole? This is pretty complicated stuff.
Mm-hmm.
Yes, it is. And, you know, I barely have a grasp on it after working on it for 3 years. So please be gentle with yourself. This is complicated. The Planning Commission did recommend D3. So D3 allows for that flexibility, an operator to mine within that 1,000-foot area. However, that maintains that 1,000-foot exclusion in the designation criteria. So the Planning Commission's recommendation did not divert from that criteria in the designation criteria. It just allows for some flexibility when someone comes in for a permit if they meet certain exceptions.
Gary, do you have any more? Because I've got a few I'd like to get into.
Oh, go ahead. Go ahead. I'll listen to you, sir, for a minute. We've got a
If you want to go right on that time, is that hitting something close to home?
I have a question just on that. So it was just that since we're talking about the 1,000-foot, and what it applies to, I had received some letters from the past, 2018, I think, where there was an argument about land trust properties being included in the definition of parks. And I was wondering if the Planning Commission addressed that, or if staff looked at that, or is that a dead issue? And just what's the status of that?
Yeah, so staff did look into that. Land trusts are not necessarily easily mapped, and that was brought to the board for their consideration back in November of 2018. So we did bring up that public comment when the board considered what parks are included in the definition of public parks and preserves, and ultimately the board did not include land trusts in that definition. So the board opted for protecting 38 parks with the 1,000-foot distance. That's not to say that mining could occur on a land trust property. It would just be subject to the permit scale. So when someone comes in for a permit, that would all be considered there.
When you say the board of county commissioners?
Yes, we had a briefing with the board on what parks should be protected, and November of 2018, the board at that time made the decision on what parks should be protected.
We did?
Yes.
Oh, my goodness. Okay. Is that a tie?
Yeah, go ahead.
Okay. Some of this might be redundant. D1, option D1 says allows expansion on designated parcels. Is there a differentiation between designated, and I know there is, but does that include existing?
So existing mines would still be allowed to operate even if they're not included on the map. However, if they wanted to expand, they would only be able to do so if it's on a designated resource land. So only areas within the map.
Okay. And then looking at option D2 on page 22, does that, they can expand up to the park boundaries?
Yeah, so this option doesn't specify, but it would allow for an operator to apply for a permit within that 1,000-foot area that's undesignated. The specific setback would be determined at the permitting process.
So it could be 500 feet, it could be 250 feet. It'll be determined. Okay. And how do we define park? Is it different than prairie or prairie land?
Yeah, so a public park and preserve, there's 38 parks that are protected, and I can't rattle them all off the top of my head, but there's specific criteria into what those parks are. And there's also a policy included in the comprehensive plan that says that these are the 38 parks that are protected essentially in perpetuity. It's not a new park that comes in the future that gets that 1,000 feet. It's only the 38 that the board elected to protect back in 2018. So.
God, you're smart. Now I'm jumping to A1. And this is on page 29. You just pretty much ended with that. And that is the staff recommendation to not co-designate ag with mineral. And but that does not co-designate 2,100 acres, but still leaves 140,000 that are acres that are designated. And you said significant public comment was received in favor of this option. Is that include people in the industry and environmental folks and forestry people like Weyerhaeuser and such? Everybody seemed to be more in favor of that one?
It was not consistent across the board. So most of the public comment that we received that was in favor of not co-designating was from citizens of Thurston County and also environmental groups, water groups, agricultural groups also. Folks from the industry, we received a couple comments that supported option A2. So I can't remember exactly off the top of my head. I think 21 comments were in favor of option A1, and there were like 6 that were in favor of option A2.
Okay. And at the end of that paragraph under A1, it says the county is currently processing a separate docket, CPA 16, community-driven review. What is the ETA of that being completed? That would take this completely off the table this year, put into next year or beyond?
The timeline for that project, CPA 16, we've just started scoping that project with your Agriculture Advisory Committee, and it's anticipated to be the end of 2021 to complete that project. That's the hopeful timeline on that. And again, I think how that relates is that we are gathering data about where important farmlands are in Thurston County that may be additional to the data we already have on the books. Also data about the relative economic importance of farmland in Thurston County. And that's all data that I think could inform a decision of whether or not to co-designate. But as I said, either of these options could move forward to public hearing. I want to be clear that staff's ultimate recommendation on this is to move all of these options, I guess, plus any additional you might want to develop, to public hearing.
Okay. And that's the bottom line today is whether we send it to public hearing or not.
Mm-hmm.
Okay. Gary, you have more?
Yes, just a couple things here.
Yeah, we got a few minutes.
Few minutes left. So staff says that take these to public hearing, but the Planning Commission says take D3 to public hearing. Is that right? No? D3? I thought that was a recommendation of
On the back page, and what is in yellow is all the recommendations of the planning commission.
We can't understand you, Romero. Sorry.
Sorry. So on the back page is a quick summary of what the planning commission recommendations are.
It's not D3?
Includes A2, C1, D3, E2.
Yeah, okay. So
Yeah,
that would go to public hearing.
Except for under A, there is a difference of opinion between staff's recommendation of A1 versus the planning commission recommendation is A2.
Okay, but if we do go to public hearing on this, can't everybody comment about whatever they think is pertinent at that public hearing? So, I mean, we aren't going to limit them and say, well, you can't talk about, E1 or D1 or whatever. I mean, if we go to public hearing, do we say you can only comment on what the Planning Commission has said and proposed?
Yeah, I'll clarify that a little bit. So the board could forward only the Planning Commission recommendation to public hearing. Staff is recommending that all of these options get forwarded to public hearing so that the public can comment on any of them. If only the Planning Commissioner's recommendation is forwarded to public hearing, then that does limit what the board is considering at that point. So staff is recommending everything get forwarded so you can hear all of the public testimony all over again.
Yeah.
But won't we hear that anyway if we forward the Planning Commission? I'm trying to give due deference, I guess, to the Planning Commission, who has studied this thing apparently to death, and for several years. We get an hour here and there that we try to catch up and be brought up to speed on it. And if the planning commission says they want to move forward to solve this problem, and they've recommended D3, are you telling me that citizens, when they come forward to comment on this process, that we're going to tell them, well, you can't say anything about E3 or, you know, D1? I've never heard that before
No.
when I've
I
been
think-
taking public comment.
No, I think, Maya, didn't you say all the recommendations would go, all the options would go?
Yeah, we would be recommending that the board forward everything to public hearing, including the planning commission recommendations. So it's not a disservice to the planning commission. It just keeps the full set of options in consideration for the public at the public hearing, and also for the board as they move through the tail end of the process. Jennifer, did you have anything you wanted to add on that?
No, I think that you're going to hear from the public probably a lot of things, including maybe options that aren't even on this table. The idea of forwarding everything forward is so to help the public understand the full scope of options and to maybe help them focus their comment on particular options or aspects of different options. And it's transparent so that they can understand everything that's possible on the table. And I think you'll get more informed public comment that way. The option for the board to just forward the planning commission set of recommendation is also perfectly fine. And you would still get testimony from the public on other options. So it's kind of a choice the board's making, I think, for transparency and to help the public understand the full scale and scope of what's being considered, and to allow for the maximum flexibility after the public hearing for the board to choose its preferred options to take action on. Staff would recommend forwarding the full suite of options.
And I would agree with that, because it respects the planning commission. It respects people in the forestry industry. It respects agriculture, and it respects the folks that are concerned about the environment. Everybody gets, it's an all-skate public hearing. Everybody gets to comment on any of these options or proffer another one forward, like Jennifer just said.
Okay, I have no problem with putting those all forward, but does that mean that a citizen that prefers, I don't know, D1, I'm just grabbing something that's not yellow on the chart that you're showing. So a citizen can't talk about D1?
They can talk about any of the options.
But are we limited then as the Board of County Commissioners to taking a piece of what they say, even though it wasn't part of the moving forward process to the hearing? Are we limited on what we can accept from the public?
No.
I guess what I'm
No,
trying to
nobody
figure out
limits
is
us.
why are we just moving forward with 4 options?
we're not.
Staff's recommendation is to move forward with all the options presented in this table.
Right.
That's what staff's recommending.
Yeah.
And
Yeah.
Oh, and Planning Commission is just recommending moving forward with 4 options.
I think that the planning commission's job is to recommend to the board their preferred options. And so that's what they've brought you. I think what staff's saying is moving forward all of these options to your public hearing will give you the maximum amount of public input that you're going to need to land somewhere amongst these options or maybe in between these options.
And I guess I'm hearing kind of from my seatmates, they agree with that. So, I mean, I'm not in disagreement with it. I'm just trying to get there. At some point, the Planning Commission has put in a lot of work on this.
But that will be part of your decision before the board takes an action, is to hear from the public, and you already have a lot of work from the Planning Commission. So all that will be weighing in before you take a final action after the public hearing.
And it's not just the planning commission, but staff and environmentalists, forestry, the miners, everybody's put they put a lot of work into this.
Yeah.
Well,
Okay, well,
so we'll hear from everybody.
I'm ready to move forward with the Planning Commission's recommendation, I guess.
Ty, any final thoughts?
I agree to put everything forward. I personally want to see a different E1, and a stronger E1. Not much stronger, but I just think that the options under E are pretty extreme on both sides. And I think there's a better compromise. So I really don't want to delay this, but I definitely would like to see another option for E1.
Hutch, won't we be able to make those decisions after the public hearing if we needed to include something
Yeah.
to make it fit?
Yes,
That's right, isn't it?
yes, it is.
Okay.
Yeah. Okay.
Well, I hear Commissioner Mensah would like to see another option before moving to a public hearing. I'd like to see the board entertain that suggestion.
I don't know if it's necessary. I hear what Commissioner Edwards just said, but I understood Maya to have said that if the board's direction is a different option, that needs to happen before we go to public hearing. Maybe it does, maybe it doesn't, but I guess I would ask her what. Do we have the option?
We would encourage that in order to be as transparent as possible with the public. Jennifer, you look like you unmuted your mic. Do you want to share anything?
No, I think you could go either direction. I think the board has discretion to take input from the public, and as long as what you come up with for final action, and Travis, please be listening and correct me if I'm wrong, falls within the range basically of what was considered and provided comment on, I think you're fine. The benefit of actually developing an additional option and getting that refined so that the public has something that it's very transparent to the public what's being offered as an additional path. I think that's something staff always recommends just because of our values in CPED about transparency. But having said that, I do believe the board has discretion on this matter of whether you wanted to make those adjustments after the public hearing or before. Travis?
Yeah, I'll just chime in on that. I mean, if you stayed with the options as presented and say the board did choose a new option, in order to avoid an additional hearing, it would, as Jennifer put it, would have to be within the scope of comments received during that hearing. So, you could go either way. The only thing is if the board is seriously considering a new E option and there is no comment, it may be harder for us to move forward without an additional hearing, but we have to evaluate it when the hearing went forward. So,
Maya said we already have a comment asking for a stronger E1.
And even a modification of option D with exceptions.
So in that case, I think based on the record, there's probably, and the deliberation and presented forward is probably, there's probably a large amount of discretion here. It may ultimately just come down to how you want to facilitate the conversation during your hearing at the end of the day.
But so at this point, they will all go to public comment or to public hearing.
That's the board direction. That's what we're prepared to do.
Yeah, I have one thumbs up.
Well, I like to see the board's at least direction on that, to take all the options presented to you today to a public hearing.
Yes.
If it's forward all the options versus the planning commission's recommendation, I'm thumbs up on that. I think it's a complicated issue and all the choices need to be out there, especially given that there's this recommendation that's different from staff.
Where's your position on that?
I guess my preference is that we move forward with the planning commission's recommendations, but what I'm hearing is all of the recommendations are going to be talked about anyway, regardless of whatever we do.
Well, that's
not if you,
I'm sorry.
Oh, go ahead, Tommy.
Yeah.
I'm sorry.
well, I was just saying, I don't think that's true. I mean, you're saying that no one's going to shut someone who already knows about all the options and wants to comment on a rejected one. We're not going to shut them down. That's correct. But I'm hoping we're going to get input from a whole bunch of other citizens that maybe have never looked at this before, have not already weighed in, and they're going to need to know kind of what Jennifer said. What were the range of choices that were worked up and offered to the Planning Commission so that they could comment on that? This is such a complicated issue that we don't always bring a lot of options to the hearing, but we don't always have an issue that has such history and complexity. So I definitely think when we get to public hearing, I agree with staff that we'll get better comment from citizens that haven't already been engaged.
So, but what I'm also hearing is that if someone comes in with an option A16 or a D42, and so it sounds like bingo, that we would still consider those options down the road if they're viable options.
That's correct.
Okay. So I'm okay with that. I'm very open.
I guess I'm just going to ask, how come we just don't recognize the Planning Commission for all their work that they've done and just go with their options, because all the options can be talked about anyway. And we can make recommendations on all of them anyway.
But because I think what Commissioner Mensah stated is clear, because if the Board of County Commissioners only move forward with the Planning Commission recommendations, only that information is going to be available to the public for them to review in detail, versus the staff recommendation, all the options and all that information associated with all the options will be available.
Okay, I'm just thinking we're going to create a lot of work for ourselves, and I want to recognize all the work that the Planning Commission did in trying to get this thing done at some point, but.
Well, I agree, but we work for all the citizens.
Yeah, oh yeah.
Like you said, not just the Planning Commission, so everybody's included in this.
We'll make it very clear in the materials put forward for your public hearing what the Planning Commission recommendations are and what those options are.
Okay.
So what I'm hearing is that consensus by the board to go ahead and have a staff submit an AIS to set the public hearing. They will include all the options presented today.
Yes.
Okay, I'm good.
Yes, I. Okay.
I'm still sideways thumb on it, but that's fine.
Well, if you're sideways on it, then if I
What's the
don't
sideways?
vote for it, then it doesn't move forward. I'd rather move forward with just the options that the Planning Commission submitted. That's what I'm in preference of.
No, I'm thumbs up. I'm thumbs up on that. I'm sideways thumb on whether I would want an alternate E1 developed prior to putting it to public hearing. So
Okay, I guess I didn't get that. Your thumbs up on the Planning Commission recommendations?
I'm thumbs up on all options going to the public hearing when we go to public hearing. On the option of when to go to public hearing, I'm sideways thumb on whether I want it to go to public hearing prior to an alternate E1 being developed.
Oh.
And I think you guys are going to outvote me on that, so I think we're going to go forward to public hearing with all options presented.
Okay, well then I'll vote with the chair on that issue to move it forward, I guess.
Well, you got me thinking though, because if another option comes in, dag nabbit, I hate this. If another option comes in, that pushes it out into next year.
Right, that's what my concern is, that we keep delaying it.
Unless an option comes in when? Go ahead, Ty.
That's why I'm sideways thumb. I really want to get this done this year. I like to get things done. You guys know that. I don't really want this to go into next year, but I also feel like I don't feel like that the E options are really capturing what,
Well, yeah.
possibility.
And in talking with people in the industry and on the environment and I'm talking about the industries, mining, ag, and farm, or forestry rather, they've all had their, I can live with this option, I can live with that option, and they're included here in this whole plan. So I'm okay with it just going as it is, all these options going.
Okay.
Okay.
Okay, so you will see an AIS coming up for you to take an action to set a public hearing and all the options presented to you today.
Okay, Ty, you all right with that?
Yeah, I'm okay with that because Travis and Jennifer and Maya say that we can still potentially listen to public hearing and basically make our own E option that's a hybrid if we feel that's warranted. So I'm okay.
Okay, perfect. So we got that. I tell you, every one of you are phenomenal. Thank you so much. This was a very good briefing, very comprehensive and understandable. Thank you, Maya, for making it understandable for me.
Yeah, very, very nice job. I appreciate it.
Very good briefing. All right, thank you all. I've got to get on out for another
Before
meeting.
you guys go, if
Yeah.
you guys don't mind, I've got a couple things that I'd like to address. Not really. It doesn't really
I have to
pertain whether or
go.
not you have a hearing.
Scott, I have to go because I have another meeting I have to get to, another Zoom.
Okay.
So do I end the meeting, Romero, and you guys can continue chatting?
Yes, because if it's another subject that is not listed on the agenda, I don't think the board can discuss that.
It's all the same subject.
Okay,
So-
well, I'm going to go ahead. You can talk, but I'm tapping out.
I'm interested.
Yeah, I'm here. I can stay.
Okay, so I just wanted to, Commissioner Menser, you mentioned something about permits and designation. And I just think it's important to point out that the way the county process has gone for years is that you apply for a permit and designation at the same time. This is the first time ever that Thurston County said, like we do with ag, like we do with forestry, we're going to designate these areas as mineral lands. The second thing is land trusts. And one of the concerns that I had with that issue is land trusts aren't necessarily parks. Some of them are working lands. Some of them are farms. Some of them are forests. There's some difference on whether or not I don't know whether or not they need protection from a mine nearby. And the third was the long-term forestry deal, because the Planning Commission has a different recommendation. That was brought to us as Thurston County was doing a review of all their long-term forestry. Staff came to us and said, these properties do not meet Thurston County's current definition of long-term forestry. That's how we came to the conclusion. And I'll say I was the lone vote not to include all of those parcels, but that's how we came to the decision to pull those parcels out of long-term forestry, as we were told that they don't meet the definitions.
Mr.
That was about all I had on those issues. But
Vice Chair, we'd like to close the meeting. Continue on.
Okay, no, I guess we're done, right? Thank you, Scott, and thank you to staff. And what's the next step then? We'll just see we'll have a request to set the public hearing at a Tuesday meeting.
Yeah,
next week.
on an agenda, board agenda setting, we'll walk you through, and I believe they're planning to have this item to set the public hearing on the November 27th as the earliest. Is that correct, Maya, or soon?
Set the hearing on October 27th.
October
and
27th, thank you. Yeah.
The hearing for November 24th.
Okay, thank you.
Very good. Okay, well, if there's no other questions, we're adjourned.
Thank you, sir. Thank you.
Thank you.
Scott, well,